Thank you, Mr. Chairman and members of the board. This morning, as you see on your calendar, we have Mr. Cion Rice and my interview with him, and good morning to you all. My interview with him was very focused. He's a very prepared and polite young man. And I understand, because I've seen the petition a couple of times, but he would be approximately 43 years old right now.
He's 43, yes.
Be 44 in September. And appears healthy and strong. Keeping in mind that in 2020, Mr. Rice did fracture parts of his face and jaw as he was working out and dropped weights of 365 pounds that fell on his face, requiring various medical treatments and surgery. And it's, you can only imagine 365 pounds. His institutional, on terms of things that are going on with him there, and before we even go there, we'll go for the original offense. And this interview was conducted in March. Actually, if I'm not mistaken, Mr. Shelton was on with the interview in and out as I was interviewing the gentleman. Original offense is murder with intent to kill, injure. Mr. Rice was 17 years old at the time of the offense. His MSR is February of 2038. On June 21st, 1998, Mr. Rice and his co-defendant, his childhood friend, shot at Reggie Rupert, who is also a member of a gang of the Gangster Disciples, who was charged by police and blamed by co-defendant for shooting co-defendant's brother to death. Mr. Rice and co-defendant knew that Mr. Rupert, to see that Mr. Rupert was out on bail as he was arrested for that shooting and was out on bail. The co-defendant was with his girlfriend at the time, Ms. Gerchanton, or Gercha, as she was known, Young. Her last name's Young. She was the victim. Mr. Rice and co-defendant fired shots and hit Mr. Rupert in the hand and the hip. Ms. Gerchan, or Gerchaton, Young, was shot and died of her injuries. Miss Young was a college student at University of Chicago, studying to be an architect. Mr. Rice and co-defendant were members of the Black Pea Stone Nation. Statements of remorse. Mr. Rice has stated in his petition, and with my own interview, his deeply sorry for, and practically can quote it, for Miss Young's death and Mr. Rupert's injuries. Mr. Rice also stated that he feels incredible sorrow towards those victims and the families of the victim and the overall community. His criminal history includes he attempted first-degree murder at 2798 in Cook County and sentenced to 6 years with concurrent to his 37-year term. Mr. Rice, at 17 years old, was arrested in connection to a gang shooting in a park where a man was injured on his face and his leg. Mr. Rice posted bond and was released. Mr. Rice was arrested 4 months later on the concurrent holding charge. We can't get into the juvenile record if we want to get into an exact. We can always go into exact to talk juvie. He had his institutional adjustments. Mr. Rice has been incarcerated for over 24 years, and he's utilized his time to educate himself academically. Mr. Rice's various program completions in his file, and in addition to Mr. Rice even achieving, and keeping in mind that with these type of serious crimes, he had very little programming ability to get programming in the institutions, as it was always on the bottom of the list for the level of the crime. He now has a teaching certificate that permits him to hold a class regarding financial literacy and more. And he did this through a correspondence course that allows him to actually teach other inmates, which he enjoys with the relationships with many of his peers there. Mr. Rice enjoys close relationships with his family, his mother, his sisters, and close friends. As recent as 10/19/23, keeping in mind the COVID period and non-ability to see him personally, and he is constantly in touch with his mother, his sister, Davina Rice, his mother, Brenda Rice Davis, and many of his nephews and nieces, keeping in mind he's not a parent. However, he's done everything he could to make sure he is prepared to give good counsel and understanding of his young cousins and his closer childhood friends. Appellate and post convictions, Mr. Rice filed a direct and appellate court affirmed both convictions and sentence. Mr. Rice then filed a pro se post conviction addressing his age at the time of the offense, and we're all familiar with. The court appointed counsel, and a new sentencing hearing was granted. New term imposed of 37 years with 6 years of murder and attempted murder. And I do understand another appeal is still pending. His reentry plan is very commendable. Mr. Rice's petition and supplemental petition state that he would reside at St. Leonard's Ministry. There he'll receive free housing, case management to assist in goalkeeping, peer group support, technology training, and mental health guidance. Mr. Rice has indicated that he has a job promised to him at $20 an hour, driving freight-type moving trucks within Chicagoland, and that's what Create Wealth, an organization. If you look them up, you'll find it has a United States Department of Transportation stamp, and is in very good standing, and is owned within his family and friendships, and have promised him a job at $20 an hour driving as he situated himself in the community if he was upon his release. In addition, Mr. Rice has also been offered services via Precious Blood Ministries, along with Iman Services, Safer Foundation, task if needed. However, there's no indication that the gentleman has been involved in any kind of drugs. His adjustments inside have been really good. So therefore, task being needed, it's available if they found to be the need. The Illinois Innocence Project plays a coordinating and resource to Mr. Rice, which would serve as a overall umbrella to helping to coordinate all of the different agencies. And most of the petition was put together as to his reentry by two established social workers within the counseling services that would be assisting him. Opposed to the release? I intelligently assume we have a state's attorney. We have letters of victims, and if they were the state's attorney's present, I'm not sure, but if they were to make their comments. But we have letters from victims' mother, sister, cousins, and one cousin is including now, and wanted to be known for the fact, as it was on her letterhead, is the mayor of Matson, Illinois, who was a cousin to the victim, Gertrude Young. A 14-year-old nephew who has never met Miss Young, and he was pretty clear in his opposition to the release, as he would have liked to have met his relative. At that point, I would ask, Mr. Chair, if the attorneys would like to make a presentation.
Okay. Does any board member have any questions for Mr. Delgado? Hearing none, we'll proceed to Mr. Rice and his attorney.
Thank you. Good morning, Candace Chambliss on behalf of Mr. Rice, also joined by co-counsel Tiffany Boyd Green, as well as James Swansea here, a policy manager at Restore Justice, and virtually by many of Cion supporters and family members. There is no question that what took place on June 21st of 1998 was a horrific event that should have never happened. Cion and his co-defendant were charged with first-degree murder for the shooting death of a young woman attending the University of Illinois, and for the attempted murder of Mr. Reginald Rupert, who was shot in the hand and hip. While Cion was not the shooter, he was found guilty under the theory of accountability. Cion fully acknowledges he was present that evening and that he participated in a series of events that resulted in an innocent person losing her life. And the weight of this is something Cion will always carry. Essentially, what took place that evening 26 years ago was a drive-by shooting. It happened over a matter of seconds. The events of that evening unfolded when Cion made the decision to leave his home when he was not supposed to do so. He attended a Father's Day celebration in a nearby park, and later that evening, he knew that he should be getting back home. He asked a friend, his co-defendant, Donzel Lowe, for a ride. Donzel agreed, but he was not the driver. Another friend drove both Donzel and Cion towards Cion's home. And about a block away from Cion's house, as the car turned, Cion and Donzel saw Reginald Rupert, who was charged with the murder of Donzel's older brother. Almost immediately, Donzel fired his gun as the car drove past, and moments later, Cion jumped out of the car and ran into his house. Within an hour, he was arrested and later charged. At trial, witnesses presented varying accounts of what happened, placing Cion in the car, outside the car, as having a gun, as not having a gun. But ultimately, as stated, he was convicted under the theory of accountability for his presence and involvement. And importantly, he does take full responsibility for his participation. I will pass it to co-counsel, who has some things to say about his resentencing and what brought us to this point today.
Good morning. He was originally sentenced to 50 years in prison at 100%. However, as Mr. Delgado mentioned, in accordance with changes in federal and Illinois law that recognizes young brains are different than adult brains, he was resentenced in 2021 under Miller and Buffer. At that time, Judge Joyce of Cook County sentenced Cion to a term of 37 years and recognized that under the current sentencing laws, any person sentenced for an offense committed when he was under 21 years of age automatically has eligibility for parole. And Judge Joyce stated that at that point, Cion had already served more than 20 years of incarceration, making him eligible for parole at that time. It's our understanding that Judge Joyce contemplated that Cion would come before this parole board for review and voiced no opposition to the possibility of Cion being released before he completes his full term. At that time, Judge Joyce also commended Cion on his disciplinary history and stated, Mr. Rice has comported himself in an appropriate manner while in the penitentiary for 23 years now. I don't doubt for a minute that that's a challenge. There are a lot of pressures and circumstances in the penitentiary, and the fact that Mr. Rice was able to comport himself in a non-inappropriate manner does tend to show a capacity for rehabilitation. He also stated that he believes Cion's statement of remorse for his role in this offense. Cion deeply regrets his actions that night, and he takes full responsibility for them. He's never claimed he's innocent, and he's never filed anything other than a direct appeal and then the post-conviction petition raising his, challenging his de facto life sentence based on his age. He's come such a long way in his 26 years of incarceration, and as mentioned, he's had limited access to meaningful programming and work, but he has carved a path for himself and for others, and at this point, I'm going to turn it over to Mr. Rice, who would like to address the board.
Before you do, counsel, would you identify yourself and which firm you were with?
Sure. My name is Tiffany Boy Green, and I am appearing pro bono on behalf of Mr. Rice.
Are you?
I work at the State Appellate Defender's Office. However, I'm not taking on this case in that capacity. I'm representing him on my own time.
Thank you.
You start.
Mr. Rice, your turn to speak to the board.
In June of 1998, I was arrested for my role in a gang-related shooting. I was 17 years old. After I was convicted and sentenced, I arrived at Menard Correctional Center to serve 56 years at 100%. I, along with other men, walked through the front door into a cell house, not knowing what would happen next. I saw grown men walking past me, and some of them asked me for my name and where I was from. I answered, and one of them looked at me and told me what would prove to be good advice in my time at Menard. Keep your head up, your mouth closed, and mind your own business. During my early years at Menard, I learned more about what it took to survive there. I knew I needed a strong mind, so I vowed never to use drugs or alcohol like many others did to block out the reality of prison. Violence and death was just a part of existence at Menard, with men hurting one another and often in their own cells. Other men unable to handle the pressure and pain of being locked away in a cell chose to take their own lives. In 2007, a man jumped off the gallery and ended his life. I had two cellmates who was committed committed suicide. One after 17 years incarcerated, the other one after 22 years. Mandoo provides few opportunities for employment in classes, and I spent a lot of time in the law library to stay out of trouble. I also learned that art was a way for me to express myself. I surrounded myself with people who wanted to better themselves. I met James Swansea, who was arrested as a teenager like I was. He was serving a life sentence, and I had been at Mandoo for several years. We grew into men in prison and had decided what kind of men we wanted to be. I wanted to be someone my nephews could look up to and who would not turn to gang members for leadership and guidance. Like James, I saw the opportunities to better myself. I enrolled in correspondence classes through prison ministry and Henry George Academy. I was interested in everything I started with, whatever classes I could find to help me become a better person. I completed class in economic roofing in College Guild. Eventually, I progressed to classes in economic money management and political science. Now, at this point, I have taken all the classes I'm allowed to take. So I have become an instructor for Henry George Academy. I currently teach political economics. I help not just the men in my class, but anyone taking classes with their coursework if they need it. I try to guide younger men who are recently incarcerated. I try to help them make good choices and separate themselves from gang. I also talk to my nephews regularly, hearing about their lives and the challenge they face. The older boys are successful athletes who plan to attend college with athletic scholarships. I'm so proud of them. If I'm granted parole, I will be able to be more involved in their lives to help them continue on a path of learning and good choices. I look forward to being an honest man in this world who works and pays taxes and spend time with people I love. I am grateful I had the support of St. Leonard's Ministry and also Precious Blood Ministry. As I stand here today, I am a different person than that 17-year-old who was arrested in 1998. Sorry does not begin to describe what I feel about what took place that night. It was a tragedy that never should have happened, and I wish I could undo the past and give Miss Young her life back. I can give my assurance that nothing like this will ever happen again. I will do my best to be someone in the community who helps steer young men and my former self away from gang involvement. I hope to be an example for them, my nephews, that person that can change and be a positive influence in this world. Thank you.
Thank you. Do
Uh,
you have any other witnesses you'd like to speak?
Yes, briefly, I just would like to emphasize that there is no part of Cion's reentry plan that was decided without first considering the victims in this case. Cion has been sensitive to where he should live so that his presence would never be an unwelcome reminder of loss. Ultimately, he decided that structure and training were what he needs most, which is why St. Leonard's and all that they provide present an incredible opportunity that we pray Cion will be able to take advantage of. He has repeatedly asked himself how he can atone and wants to begin first by listening. Cion, in conjunction with our representation, has had regular ongoing meetings with Tranisha Boyd, the pre-release supervisor at Precious Blood Ministries, who serves as Cion's case manager. A large component of what Precious Blood provides the community is restorative justice, and those who have committed violent acts have the opportunity to hear from those harmed by such acts and vice versa. It is likely that Ms. Young's loved ones do not want to hear from Cion, and certainly Cion would respect that. But through the programs at Precious Blood, he would participate in healing at least some of the community harm he's inflicted and serve to prevent and interrupt similar and future harm. Just as Cion guides his nephews, he hopes to positively engage young men like his former self, as he stated, and steer them away from similar harmful acts. I would like to introduce, with the board's permission, Mr. James Swansea. He is the policy manager at Restore Justice. Restore Justice is a policy-driven organization that advocates for reform in the criminal legal system. And as the group's policy manager, James is often here in Springfield meeting with legislators and other stakeholders about issues and bills that his office has either drafted or supports. In fact, the Youthful Parole Act, the reason that we are here today, was crafted and advanced by his organization. James has known Cion for many years now and would serve as one of his supporters should he be released. He would foster Cion's participation in Restore Justice's apprenticeship program, which James also participated in when he was released from prison.
All right, thank you. Please introduce yourself for the record and then tell us what you want to tell us.
Good morning. My name is James Swansea. I'm a policy manager at Restore Justice. I'm here on behalf of Cion Rice to show support. I've known Cion for a little over 20 years. We were both in Menard Correctional Center at the same time. I'm a former juvenile lifer myself. I spent 28 years in the Department of Corrections. I came home a little over 3.5 years ago. I actually came home a year early on clemency, but I was actually resentenced through Miller. And I just wanted to reiterate the situation that Mr. Delgado was talking about when Cion was on the yard and the 365-pound weight fell on his face. That was something that he took pride in, in doing and working out, in relieving stress. And at the time this happened, this was in Stateville. And it was no less, probably about 12 to 15 other guys on the yard. And if it wasn't for 6 of those guys that actually carried him to the gate to get help for him, who knows what would have went wrong or even worse in that situation. But that is definitely one of the most vivid memories that I have with Cion. But ultimately, while we were in Menard, we both were young. I think I'm about 6 or 7 years older than him. And the process of individuals starting to go home and get rhythm in court, it literally changes the mindsets of individuals. The punishment is going to prison already. So we were already in prison and just searching for ways and individuals with like-minded, intentions. So ultimately, that's how he and I got involved. I always kept him updated on what was going on in courts because of me having the possibility of being resentenced because of Miller versus Alabama. So that definitely was something that I used to look forward to in dealing with him, to keep him abreast and just, to make sure that he kept his head up, and like I said, always, stay around like-minded individuals because in Menard, it definitely is easy to get swept up in somebody else's situation. You can easily be on the yard and something happens. And when they do come, it's like a big sweep. You literally don't have to be doing anything. You could be on the phone. So just to be able to put yourself on the island and decide, to continually make the right decisions to hopefully one day gain your freedom, that was something, that he took pride in doing. And that was something that I look forward to talk to him about all the time. So I'm definitely in support of everything that it is that Cion has done since he's been incarcerated and trying to come home. As Ms. Chandler spoke before, we have a program at Restore Justice called FLAP, Future Leaders Apprenticeship Program. And it gives you everything nonprofit. If an individual that was once incarcerated has came home, wants to start a nonprofit organization, that is what we try to give them the tools to do. But you ultimately get so much more because you deal hands-on with our staff. Half of our staff is impacted. Our executive director is also a formerly impacted former juvenile lifer by the name of Wendell Robinson. And that's a program that he started. So we have a network of positivity. We definitely try to make sure that individuals stay on the right path. We also have a returning citizens network. And this is made of individuals who have also served time. I think it's like 250 plus, whether you've served a substantial amount of time or just a couple of years. We do meet once a month, whether it's support or we actually have certain issues that we talk about. And this is something that will be afforded to Cion. And I have no doubt that, if released, he definitely will continue to do the right thing because he's been doing it now with so much less. And that's something that individuals that are incarcerated that want to make changes, that's something that they have to do. So thank you for your time.
Thank you for your testimony. Mr. Delgado, do you have any questions of the attorney or his witnesses?
If I could just briefly conclude.
Please, that's what I was going to ask, if you can conclude, because, Mr. Chairman, I am asking for an executive moment, to discuss on the juvenile side.
Okay.
Thank you. We'll conclude by noting that Cion is incredibly fortunate to have a release plan that provides housing at St. Leonard's, where he'll have access to on-site counseling, job training, life skills training, and a wealth of support. St. Leonard's has been in the business of assisting returning citizens for over 70 years, and the recidivism rate for their participants is much lower than in the general population. There is no better place for Cion to reacclimate to life outside of prison. Additionally, Cion will continue to work with his case manager at Precious Blood, with whom he's met bi-weekly now for approximately 16 months. He will have access to the restorative justice approaches, group counseling, and just wonderful personalized support. Upon completing St. Leonard's job training program, he has confirmed deployment with the local truck agency. He has a large family who love him dearly, and he has a network of men like Mr. James Swansea, who are doing incredible things in their communities and who will enfold Cion into their meaningful work to support him. All of these factors, according to study after study, decrease recidivism and involvement in criminal activity and contribute to community safety. Cion is now in his 40s. He's 43. This substantially lessens the likelihood of any future involvement in the criminal legal system. And just to reemphasize that this reentry plan is in place today. There is a bed waiting for Cion and a level of support that few people manage to secure from prison. He would be subject to MSR for up to 10 years, which would put in place additional support should this board see fit. For these reasons, we respectfully request that the board grant parole and are happy to answer any questions that members may have. Thank you.
Thank you. Mr. Delgado, you have a motion to go on executive session first?
Yes, I do, Mr. Chairman.
Second?
Second.
Motion's been made and seconded to go on executive session. We're going to ask all the participants and concerned citizens to leave the room. Take all your recording devices, including your cell phones, with you. We'll bring you back in, at which point the board will be open up for board to ask you questions and any other information we might need. Thank you. Bye. Delgado, anything further you want to say at this
Thank
point?
you. No, at this point, I'm open to the questions of the members and comments before I read my rationale.
Okay. Any questions for the board for either Mr. Delgado or counsel or Mr. Rice?
I have, you go.
Mr. Bullock?
Okay, yeah, actually, I was looking for a little bit of clarity on the accountability piece. Within the petition, I think the version of events was somewhat vague in my opinion. The language of theory of accountability has been used this morning. But statement of facts is pretty specific that it was in fact the petitioner who shot the individuals, the victims here. Could you provide some clarity for where the petitioner is at today?
Can you hear me? Okay, thank you. Yes, so the evidence at trial did point to the co-defendant, Donzel Lowe, as the shooter in this case. Testimony did vary. There's no dispute that Cion was present that day. There were 5 witnesses questioned. 2 witnesses said they saw Cion with a gun. 1 witness thought they saw Cion shooting, but this testimony was inconsistent from what he provided to the police at the time of the incident. He originally told police he saw the Cion exit a vehicle and shoot, and then later denied having stated that. The victim in this case, Mr. Rupert, according to the state, was in the best position to view the shooter, and he was unsure as to what he saw and reported to police that he saw only Donzello as the shooter. Therefore, additionally, the physical evidence supported one shooter as well. The shells that were recovered were from a single weapon. And so the state did proceed under the theory of accountability in their closing, and in the instructions to the jury, the judge proceeded under that theory as well. Cion knows that he's legally responsible for his presence and therefore guilty of first-degree murder and attempted first-degree murder. And he does take responsibility for the tragedy.
Okay, thank you.
Mr. Ronas?
I want a little clarity or update as it relates to the gang affiliation. You know, this was a case of gang retaliation where he was responding to the loss of his brother from the other gang. So I know you document that there is no association since 2000, right? Is that, I mean, my question is going to go to you, counsel, and he can, you know, Mr. Rice can also chime in very briefly. Is there a concern in community for any type of retaliation, you know, of harm towards him? I understand that if there hasn't been any activity since 2000 in institution from another gang, can you just enlighten us as to his affiliation or potential community concern?
Certainly. Yes, since 2000, Mr. Rice has had no affiliation and does not consider himself a member of the gang. As Mr. Swansea and other members who are in prison can attest to, that affiliation stops when they make the personal decision to better themselves, to not associate. And it's a difficult thing to do, particularly in a place like Menard. But he made that choice because he recognized that's what led him to prison. That's what took someone's life, was that affiliation. So he's not, well, he can't predict the future that there would not be some retaliation. There's no indication that there would be. He has certainly made the decision to live in a manner that would remove him from those sorts of elements, and he wants to help prevent that. So he would be at St. Leonard's with men similar to himself who are bettering themselves and want to contribute to their communities in a meaningful way. So I don't think that is a concern at this time for him.
Thank you.
Any other questions from board members?
I understand what you have to say about the gang affiliation, but there is institutional discipline in 2007, 2017 regarding gang affiliation.
Yes. As Mr. Swansea spoke about at Menard, there are often incidents where everyone gets involved, or everyone gets ticketed, whether they were involved in an incident or not. So the 2007, he was present. He was on the yard that day. There was a sweep where there was an incident between members of gangs. Correctional officers came and literally ticketed almost everyone who was there. Mr. Robinson, who is the executive director of Restore Justice, where Mr. Swansea works, was on the yard that day. He was at the prison at the time at Menard. He knows Cion well. And he remembers that. He remembers that everyone was ticketed. He was not ticketed because he was working, but he saw that Cion was on the phone and was not involved in any way. Cion has grieved the tickets that he's been accused of gang affiliation. He has affidavits saying he was not involved, but in both instances, they were incidents of multiple people being swept up into the events that he did not personally have anything to do with.
And could you give a brief update on the current status and basis of the appeal that's pending?
I will let co-counsel address that. The appeal is not pending to my understanding.
Correct today. At the time you filed the petition, the appeal was pending, but that is no longer the case. And his sentence of 37 years was affirmed by the appellate court. There is additionally a petition for leave to appeal filed on that, but that was denied. So that appeal is no longer pending.
I have no further questions.
Okay, Ms. Goff.
I understand about saying that we take responsibility. We have a restorative justice clinician, practitioner here, friends. What I haven't heard is how you've accepted the obligation and responsibility with regard to the harm to the victim's family and how you would move forward on repairing the harm or consideration for repairing the harm to the victim and to the community. I have not heard that.
Yes. As we talked about the restorative justice relationship with Precious Blood Ministry, part of the reason he's been so close with his counselor there and talked to them is because that is something that is on his mind. And that is why he wants to be involved with speaking with victims' families, even if it is not the direct family that he impacted. He wants to try to be a positive force for other families of understanding how such harm can happen and to be a role model for others, to interrupt future violence, to work with his own family.
I would like to hear it from him, please. Mr. Yes, I would like to hear from you. Your you said I take responsibility for the harm that I caused to the victim.
I truly take responsibility for what happened that night. And I try to better myself so I can change and show everybody else how I got in that situation and stop them from leading to that situation. That's why I write to the community like Father Flake. I wrote to him about the youth in the community that's involved in the activities and give them something better than we had. We didn't have nothing to do. So that leads you to the games. It's something else we need to show them, then let's say stop. And you gotta show somebody else something else and then getting deeper because the kids is getting younger and younger doing stuff. And I look for something, a solution now to solve the problems. I look for more solutions that we can find more solutions and everybody talking about the problem. I look for the solutions. So I look and see, why is he out here doing this? Why is he out here doing this? And I definitely take full responsibility. I've been trying to better my community. My friends, kids, still, some of them do grow up in their community, even though they're not in the gangs, which that's good. Like my nephews, I try to make sure any insight that I can get them to stay away from that. Sports is a tool to keep you away from that, but sports go so far. Like my nephew one day, he said, man, my friend's starting to be in gangs and hang out on the corner. He said, I told him no. He said, but I said, look, you did better than me. You told them no already. So now we about to make sure you stay away from all that. I tell him every day, my nephew right now, there's the second one, he's 17 years old, the athletic scholarship. He's ready, and I say he's not even near a game.
Please, what I'm wanting to hear from you, sir, is the obligation you have to the victim's family and what you've considered with regards to repairing the harm that you caused to that family.
I apologize. I can't apologize.
I know you can't face to face.
Right, so I apologize to the victim family more than I can ever do. So that part I take.
How have you done that? In what medium? In what way, sir?
I apologize to the family and take part in everything I did. I apologize for everything that I did. I should have never even been in that car that night. So that right there, I apologize. I'm in the full circle. I'm trying to restore and right my wrongs. I'm trying to right my wrongs for what I did.
And if I can just join in and explain, you asked in what way he apologized to the victim's family. At his resentencing hearing, he gave a very detailed and genuine statement of remorse, which Judge Joyce found to be very believable, credible, sincere, and the victim's family was present in the courtroom at that time. So that was the way he relayed his apology. And additionally, he will be working with Tanisha Boyd on different ways that he can help work with the family, but he needs to be out to be able to participate in those other ways.
Okay, thank you.
Any other board member with any questions?
Just, I'll make a statement if I could. Mr. Rice, I just wanted to let you know, we're clearly faced with the difficult task of weighing your reformation against the gravity of the underlying offenses. which I know in this case included 2 attempted murders as well as the homicide. And I just wanted you to know, regardless of the outcome of this hearing, that your efforts are seen and that the challenges of accessing programming within IDOC are recognized. And I understand that the real work is in how you carry yourself each day, and you do appear to be putting in that work. I just want you to be encouraged in those efforts. It was also very clear from the petition that you've been blessed with a very strong support system that loves you deeply. You had a young nephew that wrote of your good heart and soul, and many others that spoke on your behalf. And they clearly will continue to be watching you and be influenced by you. I really encourage you to continue your efforts.
Is there anybody from the audience with any objection at this point? Seeing none, Mr. Delgado.
Thank you, Mr. Chairman and members of the board. And Mr. Rice, the rationale and decision of this case is Mr. Rice has accomplished many positive, and by the way, Dr. Globokar, thank you for that preface. Mr. Rice has accomplished many positive programming, corresponding courses, and education credentials. Mr. Rice's reentry plan is a solid one. I'm sure that Mr. Rice would abide by his conditions if paroled. He enjoys the support of many reentry organizations if he was to be released. Ms. Gerchanton Young was a young upward-bound architect at the University of Chicago. And Ms. Young, who is gone, just as I've described and echoed all of the accomplishments of the gentleman, Cion Rice, who was in this unfortunate situation that evening, I do reflect the letters and all of the victims of family members who have engaged and have contacted the board. And as I described their thoughts, however, many loving family members remain here. Ms. Young was the seventh of 14 children. These victims remain with painful thoughts and missed birthdays and holidays. Ms. Young was described as the first to make it and being in a career. These victims have spoken up diligently in your files, and because her youth and being the innocent bystander, basically, therefore weighing if indeed Mr. Rice would follow his conditions of parole. Yes, he would. Does Mr. Rice have support of his family reentry programs? Yes, he does. However, would releasing Mr. Rice deprecate the seriousness offense that took Ms. Young's life? It's my finding that it would. Therefore, taking all aspects of the case and keeping in mind the victims' rights, and that they're alive and contacting this board from similar communities, which in many ways has so much irony in it. In fairness to Ms. Young, whom was innocent, it's my recommendation that Mr. Rice's parole be denied at this time.
Thank you. Second?
Second.
Motion's been made and seconded to deny. Clerk Alley, you may take the roll.
Mr. Delgado,
Aye.
Mr. Boland,
Yes.
Mr. Coates,
Yes.
Ms. Globoker,
Yes.
Ms. Goff,
Yes.
Mr. Grubbs,
Yes.
Mr. Heaton,
Yes.
Ms. Schaffner,
Yes.
Ms. Taronis,
Yes.
Ms. Tyson,
Yes.
Mr. Tupy.
Yes. Motion to deny is passed 11-0. Thank you for your participation. I will advise you that you can always file a clemency, and we can consider that at some other time. Thank you.
Okay, correct. So the law is that you'd be eligible for 10 years again, but clemency is available to individuals at any time to petition.
All right, we'll take a 5-minute break, and then we'll come finish up with the last case, which I believe is Mr.
Okay, let's unpack this, and we'll go through some of the documents, but I'll make it a faster unpacking than normally do just because of the number of hearings that we're going to go through tonight. So let me know if you want me to do a separate video with a longer unpacking. Email me or put it in the comment section. But again, I just, for me, this is, it's just surprising. It's surprising that Illinois a state that I just have always had these certain assumptions about would be lenient on crime. And at least as far as it goes with their Supreme Court, their appeals, and their paroles, they're not at all. I mean, we could have seen easily Louisiana grant in this situation, definitely in Connecticut. And I'm just blown away. And now keep in mind, if you haven't seen it yet, we saw a parole hearing that happened the same day as this already. And it took place right before this case. And it was a man who had taken a life when he was 16. But then he became the first man in DOC history to get accepted into law school. He just, did couldn't have had a more productive time in DOC. And 3 of the board members denied his application for getting parole just 2 years early so that he could serve law school while not in the DOC. And they only needed 4 to deny him fully so that he would have gotten denied. So he got through on the skin of his chin, and they had 0 grant this man's early parole. 0. I'm not saying he should be granted, but I'm just shocked. Again, it's Illinois. It's a state that I would just assume would have granted. Now, if you want to take a step back and remember that, and maybe there's just differences in terms of how they handle parole and how they handle everything else. But and this all ties into legislation, and there's things that are grandfathered in, and things move in weird directions when it comes to law. But he was out on bond just 4 months for attempted homicide. He had shot someone, and a judge had let him out on bond in 1999. And the man he killed had killed his or his co-defendant's brother and was also out on bond for actually killing someone. So you at the same time, you do have 2 people that were out on bond who had long criminal records, one for homicide, one for attempted homicide, when this occurred. And of course, if they had, maybe more common sense bond laws, none of this would have happened. So, you have both sides of justice there. And again, so I know I have to move quicker than I normally do. He's been locked up for 24 years. His parole date is 2038. His discharge date is 2041. Those can feel like life sentences for him. Also, keep in mind he's not allowed to apply for parole. It's automatically baked in for another 10 years. So they just signed 10 years onto his DOC life. Those board members, without hesitating, without exception. And in other states, you can just reapply and go for parole again. So again, another shocker or surprise by Illinois, not something you would expect. So a few things about the hearing that I'd like to point out. It's interesting that he has these attorneys doing it pro bono, but it didn't seem like he was properly prepared. Now, in their I guess in their defense, it did seem that they tried their best to avoid having their client speak, but the parole board, to their credit, insisted on hearing directly from him, and he maybe was nervous or not exactly prepared, but didn't give the response they were looking for. And there's something interesting about how the attorney's claiming that there was only one gun, there's no proof, and those are in his appeals, and it's not clear to me. But she also stated it showed that there was only one shell matched to one gun, and that's a little bit sketchy, because you can have both 9mm guns, and I saw nowhere in the appeals that they ran ballistics on the shells to match it to one specific firearm, which I don't even know if you can match shells to a specific firearm versus the round. And I have also heard that a lot of that is wacko science anyways, ballistics. I heard that. I have no idea. the Miss Young, the victim, unlike one of the board members said, the irony in this case, it is so tragic. What was she? One of 16 children, a middle child, number 8. And she's the first one to go to college. She's becoming an architect, and she has to get hit in the crossfire. And that's just incredible. And again, I think we got to go back to the judges that handed out these to both of them, the one who was killed and the one who shot them, bond. I mean, that's just insane. But I digress. So he does have another appeal going, and he can file for I guess a commutation of sentence like they had suggested. And with his attorneys, you might assume that they will go through that process. Let's just jump into the files. And there are 3 documents on this case, his appeals and the initial, but I'm not going to go through it again because of the time constraint. But thank you, Richard, for going through all of this. And I'll give a thank you again to Griggs for letting us know. And he's an Illinois native, so letting us know that this existed. And normally, I also want to point out, they normally have 16 judges. I had another Illinois native send me information. The judges are quite impressive. The resume, much more impressive than even the other states that we follow. So they follow, it's like, I love seeing the different cultures in these parole hearings. To me, it's just fascinating. Like, you can really get under the hood and into the heartbeat of a state by, I think, seeing how they run these systems and how it's really fascinating to me. I don't know. So here is that we'll go through this quickly and only partial, but this is the initial court doc from 2001. People versus Rice is his appeal. And the appeal, of course, came not in his favor, but the defendant and co-defendant were charged with indictment of 5 counts of first-degree murder, 3 counts of, I don't know why it says 5 counts. Maybe, is that a typo? You would think that's attempted. What am I missing here? 3 counts of attempted first degree, 1 count of aggravated battery with a firearm, 2 counts of aggravated discharge of firearm, 2 counts of aggravated battery. The defendant and co-defendant received separate trials. A jury convicted the defendant of first degree and attempted first degree. At the sentencing hearing, the state presented multiple of victim impact statements. The trial court granted a motion by the defense asking that it consider only 3 statements from the immediate family murder victim and not those of friends of the employers. The trial court sentenced the defendant to concurrent term to 50 years in prison of first degree and 10 years of attempted first degree. And these were to run straight, so no parole. It's basically felt like a life sentence, certainly. Then he appealed a sentence. Oh, on that note, also, what do you think? He's talking about lifting the weights, 300 something pounds, and it crushed his face. Do you think that when they said it was an yard accident, or do you think it actually was an accident? I'm not so sure, and I wonder if the board members were thinking that too. Does that mean it's gang affiliation? I don't know. To me, I was just wondering if it was really an accident. Certainly could have been, but it all makes me wonder. According to the Reggie Rupert, at about 11:20 p.m., a maroon car came down the street with 4 people inside. So there's 4 people in the car. 2 men in the back seat started firing at them. This is where they said it was 2 of them holding weapons. Reggie testified that he recognized the man in the back seat on the driver's side as Mr. Rice, whom he had seen a few times previously around the neighborhood. He recognized the man in the back seat on the passenger side as Mr. Lowe, his co-defendant. Reggie further testified that when the shooting started, a few bullets went by him, and then one hit him in the hand and another hit him in the hip. He fell to the ground behind the car. Shortly afterwards, he heard Camara screaming Gertcha's name. He did not see either Mr. Rice or Donzel exit the car during the course of the attack. When the police came, Reggie told him that he recognized the gunman as Donzel and Mr. Rice. Paramedics then arrived at the scene and took Reggie to Christ Hospital, where he remained for 2 days. 2 detectives interviewed him at the hospital. For only 2 days. Wow, getting hit in the hip and hand. Terrell Robinson testified that the neighborhood where the shooting took place was controlled by gangster disciples. I have seen a few documentaries on that group. Terrell said that he thought Reggie was a gangster disciple, but did not know for certain. In the day before the shooting, Mr. Rice had been riding around the neighborhood on his bicycle. As he did, he would often make hand signs insulting the gangster disciples. 3 days prior to the shooting, Terrell had been standing outside Reggie and some of the gang members. Mr. Rice passed on his bicycle and pointed at Reggie and said he was going to kill him. Terrell said that on the night of June 21st, 1998, a reddish car drove by. Mr. Rice, with his hands out the window firing the gun. Mr. Rice was in the back seat on the driver's side, said Terrell, and Mr. Rice was the only person that saw with the gun. He did not see anyone get out of the car. After he heard a couple of shots, Terrell started running. He took refuge in the neighbor's house, and he heard the cars pulled off. So this is they're going through the different testimony, and in the appeals, there are some contradictions that certainly create a doubt whether he actually did have a gun. But again, I'm not going to go through all of that. But in a nutshell, it was, of course, he didn't get his appeal, but then he later did get a reduction on his sentence through an appeal. Although in that they bring up certain points where he was 17 at the time. He was about to turn 18. They're like, this shouldn't even make a difference. He was on bail. So what do you think?
Young, her last name's Young. She was the victim. Mr. Rice and co-defendant fired shots and hit Mr. Rupert in the hand and the hip. Miss Gerchon, or Gerchaton Young, was shot and died of her injuries. Miss Young was a college student at University of Chicago, studying to be an architect. Mr. Rice and co-defendant were members of the Black Pea Stone Nation.